Good evening, good evening, good evening. How do? How do? Come on in for this one. Come on in for this one. What we're going to talk about today is the appeals process that would be under Article 78. Under Article 78, basically under Section 75, when you go through disciplinary actions as a civil servant, once they made the decision, when you went to arbitration court, after their decision, you have what you call 20 days. They say 30. No, it's 20 days to file for appeal. Now, you're going to file for an appeal with the Civil Service Commission. Okay? When you file with Civil Service Commission, once you have your appeal there, basically everything's final. Right there. And that must be done within 20 days. But the other route would be Article 78, which is you have up to 4 months. We're going to talk about this because as that machine ran its deal, the good thing about it was once they made this decision, I responded to the union 14th Street. I called the grievance coordinator who represented me, and I told him that I have the letter, and I'm basically responding to his facility to basically start this appeal process. Let's just say he took off before I got there. The good thing about it, went there with another officer who's now on the level of sergeant from a different entity. It's cool having those officers from different entities, especially when they roll with you. She wasn't from Health and Hospitals, and she wasn't from HRA. Right, Sarge? So, we go there. She sits inside my vehicle. I go inside. As I go inside, sign in, go upstairs, I'm greeted by one of the staff. Here's the thing about your representing union, who's supposed to represent you. She addressed me and she said that the grievance coordinator, Todd Rubenstein, was gone for the day. Who knew I was on my way? Not a problem. When I asked the individual what was her name, they give me this first name basis. No, what is your name? What is your name? So I can document it that I came here and I spoke to you in reference to this situation. Oh, I'm just going to give you this name. Okay, that's totally unprofessional. And the key thing is that this is your representing union with this one name thing. What's going on there? It's questionable right there. It sounds like you're trying to deceive me. Moving forward, the grievance coordinator was supposed to contact you within the 4-month period. To set up basically conference and discussion on how we will go about fighting to get your job back. Especially since they know that they use deceptive practices. Now, the key thing about the deceptive practices is, number one, you violate Civil Service Law Section 75B under the whistleblowers. Now, we're going to say under the whistleblowers, we're also going to add New York State Labor Law 740. We're also going to add New York City local law number 33. We could also add that federal law. The key thing in doing all of this, when you didn't want to do it that way, you violated my right and my privilege. Get it? That would go under that Jackie Robinson. Federal law. USC Code 42. Deprivation of a right or privilege. You deprive me of these rights to use of these laws on the whistleblower. So, like I said, you have 4 months to get back to the officer, and you fail to do so. This is to deprive the officer of the opportunity. Needless to say, it didn't matter. Why? Because the employer entered into contract with fraudulent information. Said actions to do that is basically, as we say, enter into contract into void could constitute fraud. So, based on the fact that the employer entered a contract with false information and failure to follow due process under civil service law, said contract is in void. That will fall under your Fifth and 14th Amendment, which brings about your rights, your fundamental rights of due process. And the key thing is they violate any part of due process, even the minimal part. Said actions in a decision is vetoed. You made a decision? Yeah. Can you show that they violated due process? Yes, I can. The information they used was fraudulent. The failure to exercise or recognize the whistleblower that was in place. Violation of due process. You continue after he was told. Thought it was best. We're gonna work this guy out. Yeah, we're gonna work him out. Not a problem. So you violated the due process. So you entered the contract in void. It's vetoed. Oh, so what about this appeal you're talking about? Why would you appeal a contract that was entered into void? It's been vetoed. So all you have to do is show how the violation of due process. See, when you enter, the key thing is how the deceptive practices, they went beyond the so-called statute of limitations. Right. The 4 months. And then statute of limitations on the whistleblower, we would say is 2 years, and the other one says 3 years. Regardless of that, there is no statute of limitations. Why? Because you enter into contract with dirty hands. You can't enter into contract with dirty hands. You must be with clean hands. Based on the fact that it was dirty hands, that's entering a contract in void, which is fraud. Hence, why would I go and set up the Article 78? If you do, the first thing they're going to say, hey, statute of limitations ran, let's close the case. There's nothing you can do. Really. It's a beautiful thing about law. Really. So all these deceptive practices right here, can you prove these deceptive practices? Sure. Prove beyond a burden of proof. Under a burden of proof, you would need to bring about under civil law. You have to come up with a burden of proof. Under a burden of proof, you must provide a preponderance of evidence. So, in this preponderance of evidence, we use their We use their documents against them. What is your corporate compliance policy? How do they violate the corporate compliance policy? Said corporate compliance policy, which brought about their department issue memorandum, patrol guide, or security manual, and how they violated that. How they violate that. One sergeant doesn't know how to fill out his memo book, and he's putting in lies in his memo book. 2 days later, that's an accusatory instrument. How are you going to enter something in that 2 days later? The other sergeant giving the officer orders while the officer's off duty, yet not properly putting the officer on duty, nor sending the patrol vehicle to pick up the officer to bring him back to the command facility. Failure to supervise. But yet you're gonna write an instrument saying, "I told him to do this and that." You could tell anybody anything. Yet, like I said, was he on the clock? No. Did you put him on the clock? No. Did you send transportation? No. So where's the insubordination? You get these guys that say, these old school guys, oh, just do what they say and you rebuttal it later. So they said jump off the roof. You're just going to jump off the roof because they say so? Your supervision. You hold accountable just as the other employees are held accountable to your actions. Stay within your guidelines. If you can't stay within your guidelines, either go get a refresher course or do something else. I don't know what to tell you. All right? But let's get back to this appeal process. You can't come with this fraudulent information and then go into court, into a tribunal, use it, taint the officers of the court, who's all working in cohesion, who basically violate their canons by actions of ultra-virus. Once you can establish that ultra-virus has occurred and the violation of due process under the Fifth and 14th Amendment, the substantial rights kicks in and substantive right kicks in. And that goes and vetoes every action that was done. You can Google this. Look up Black Law Dictionary. Drop down the app. You can read this. You think nobody can do this? Anybody can do this. So on that note, once again, the facts cannot be altered nor denied. You guys have a wonderful evening. And I'm out. Later.